important MCQs on law of crimes, that is Indian Penal Code. These questions are very important for LLB students. LLB first year, BA LLB 5th semester. I hope this video will be enough for you to appear in the examination. Let's start. Abettor is a first person who commits the offense, who instigates the commission of offense, against whom the offense is committed, or who is innocent. Abettor is a person. Abatement is defined in the section 108 of IPC, and abettor is a person who instigates the commission of an offense. B is the correct answer. Next question. A instigates B to murder C. B refuses to do so. Which one of the following is the liability of A? Since essential to constitute an offense of abatement are not fulfilled, A is not guilty of instigating B to murder C. B refuses to do so. The refusal of B to act on the instigation of A puts an end to the matter, and A is not guilty of any abatement. Since the offense was not committed, there can be no abatement for an offense which is not committed. Hence, A is not liable. A is guilty of abating B to commit murder. As to constitute abatement, it is not necessary that the act abated should be committed. Option D is the correct answer. A is guilty of abating B to commit murder. As to constitute abatement, it is not necessary that the act abated should be committed. So, D is the correct answer. A rich guilty intention abates P, a child of 6 years, to commit theft in B's house. The act is not committed. Here A is guilty of theft, guilty of no offense, guilty for abating theft, guilty of attempt to commit theft. Here A is guilty of abating for theft. A, who is 19 years of age, instigates his sister B, who is 6 years of age, to pick the pocket of a co-passenger. As soon as B slips the purse of the co-passenger in her school bag, she is caught. However, when the purse is opened, it is found to be empty. In this case, which one of the following statement is correct? B does not commit any offense. B is 6 years old and A is 19 years old. B does not commit any offense because B is below 7 years of age. A child below 7 years of age cannot commit any crime. A is guilty of abatement. This is correct. B does not commit any offense, but A is guilty of abatement. This is the correct answer. Abatement of an offense is always an offense, may be an offense depending on the circumstances, but not always. Never an offense, may not be an offense depending on the circumstances. No, abatement of an offense is always an offense because it is not necessary that the act abated should be committed. Therefore, abatement of an offense is always an offense. A instigates B, a person of unsound mind, to set fire to a dwelling house. B, incapable of knowing the nature of the act that he is doing, what is wrong or contrary to law, sets fire to the house in consequence of A's instigation. Which one of the following statement is legally correct? Since B is incapable of committing offense, A is also not guilty. No. B has committed no offense, but A is guilty of abetting the offense. It is correct. Both A and B are guilty. No. B is not guilty because B is a person who is of unsound mind. So B has committed no offense, but A is guilty of abetting the offense. A instigates B to instigate C. A instigates B to instigate C to murder Z. B accordingly instigates C to murder Z, and C commits that offense in consequence of B's instigation. A is not guilty of any offense, not guilty of abetting murder, guilty of abatement of by conspiracy, guilty of abetting murder. It should be guilty of abetting murder because he was the first person to abet B, then B abated C to murder Z. So A is guilty of abetting murder. B, with the intent to temporarily use W's money and later on return it, instructs C, his 6 years old son, to take away W's purse containing 20,000 rupees without W's consent. C carried out the instruction. The criminal liability in this case is C is guilty of the theft and B of abatement to commit theft. No. C is 6 years old, Dolly in capex. B does not commit any offense, but C commits the theft. No. Both B and C are not guilty of an offense. No. C is not guilty. B is guilty of abatement of the theft and C is not guilty of any offense. This is correct. B is guilty, C is not guilty because C is 6 years old. A child below 7 years old cannot commit any crime. In which alternative out of the following there are only inchoate offense? Abatement, conspiracy, bigamy, abatement, conspiracy, attempt, bigamy, kidnapping, abatement and sedition. What is inchoate? Inchoate means an incitement or conspiracy anticipating or preparatory to a further criminal act. That is called inchoate. That is to excite someone. So in which alternative out of the following there are only inchoate offenses? It is abatement, it needs excitement by someone, conspiracy the same way, and attempt. These all are inchoate offenses. Option B is correct. A incites B to beat C. Subsequently, A reaches the place where B is beating C. A is liable under Section 34, Section 109, Section 114 and Section 115. A incites B to beat C. Subsequently, A reaches the spot where B was beating C. So this will be punishable under Section A is liable under Section 114, where the abater himself is present in the crime place of crime. Abater present when crime is committed. Section 34 talks about acts done by several persons in furtherance of common intention. Section 109 provides the provision of the act abated is committed in consequence and when no express provision is made for its punishment. And section 115 is providing the provision for abatement of offense punishable with death or life imprisonment. So section 114 is A is liable under section 114. X instigates Y to commit murder of Z. Y in consequence stabs Z, but Z survives the wound. X is guilty of murder, attempt to murder, abatement to attempt murder, and abatement of murder. X instigates Y to commit murder of Z. It is clearly an abatement of murder. Which one of the following statement is correct? In conspiracy, there is no distinction between principal and accessory. In conspiracy, principal and accessory are distinct. There has to be a distinction between principal and accessory in all offenses. None of the above is correct. In conspiracy, there is no distinction between principal and accessory. This is correct. A agree with B that he will help B in copying in his examination. This is an act of criminal conspiracy, abatement, common intention, or common object. It is criminal conspiracy. It is having a common object, common intention. It is a criminal conspiracy. To constitute an offense of criminal conspiracy under Indian Penal Code, what is the necessary condition to be proved? There must be a prior meeting of two or more persons. It is required. There must be an agreement of two or more persons to do an act illegal or to do a legal act by illegal means. A person does an illegal act with the help of two or more persons. Two or more persons commit a crime on a sudden provocation with guilty mind. The answer should be there must be an agreement. Must be an agreement of two or more persons to do an illegal act or to do a legal act by illegal means. This is criminal conspiracy. The criteria should be fulfilled. What the criteria are that there should be two or more persons and they should meet prior to committing that crime and to do an illegal act or to do a legal act by illegal means. This is criminal conspiracy. An agreement is designated as criminal conspiracy if two or more persons agree to do an illegal act. Is correct. Some illegal act is done by all parties to such agreement in pursuance thereof. Any illegal act is done by at least one party to such agreement. It is two or more persons agree to do an illegal act. It is correct. In which section of IPC the definition of criminal conspiracy is given? Section 120, Section 120B, Section 120A or Section 120T? Criminal conspiracy is given under Section 120A. This is the correct answer. Criminal conspiracy under section 120A. Punishment for criminal conspiracy is given under section 120B, and section 120D is not available in IPC. It is not available in IPC, and section 120 is concealing design to commit offense punishable with imprisonment. So in IPC the criminal conspiracy is given in section 120A and its punishment is given in section 120B. Under which provision of the Indian Penal Code punishment for criminal conspiracy is given? It is section 120B. A and B plan to murder C. The next day, they are guilty of the offense of planning, the offense of criminal conspiracy, the offense of attempting to murder. No offense. A and B, both they are two persons. They are planning to murder C. It is a criminal conspiracy. The offense of criminal conspiracy. The option is B. When A dies as a result of an act of violence by person B, person C not present at the scene of the crime can be prosecuted under the Indian Penal Code under section 120A to 120B of the Indian Penal Code, under section 141 to 149 of the Indian Penal Code for an act done in furtherance of common intention under section 34 of the Indian Penal Code for vicarious liability, as C was aware that offense was likely to be committed by B. No. When A dies as a result of act of violence by a person B, person C not present at the scene of crime can be prosecuted under the Indian Penal Code under section 120A to 120B of the Indian Penal Code, which defines the criminal conspiracy. Under section 120A and 120B provides the punishment for criminal conspiracy. In criminal conspiracy, it is not required that the person C to be present at the scene of the crime. When two or more persons agree to do or cause to be done an illegal act or an act which is not illegal. By illegal means, an act which is not illegal means an act which is legal. By illegal means, such an agreement is designated as criminal conspiracy, designated as criminal abatement, both criminal conspiracy and abatement, none of the above. It is designated as a criminal conspiracy. For criminal conspiracy, the minimum number of persons required is 2. What is not necessary to constitute an offense of criminal conspiracy is 2 or more persons it is required, 5 or more persons it is not required. If an act is not crime, to do some act in pursuance of agreement. What is not necessary to constitute an offense? If act is not crime, that is act is legal, to do some act in pursuance of agreement. Legal, that is to do some act in pursuance of agreement. This is also not required. This is what is not necessary to constitute an offense of criminal conspiracy. 2 or more persons, this is required. 5 or more persons, this is not required. If act is not crime, that is legal, to do some act in pursuance of agreement, this is required. Agreement to cause illegal act, all these 3 are required. This is not required. The answer is 5 or more persons is not required or necessary to constitute an offense of criminal conspiracy. Which one of the following is not punishable under the Indian Penal Code? Preparation to wage war against the state, it is punishable. Preparation to commit murder, it is also punishable. Preparation to commit dacoity, it is also punishable. Preparation to commit depredation on the territory of a friendly power. Which one of the following is not punishable under the Indian Penal Code? Preparation to wage war against the state is punishable. Preparation to commit murder, but the murder is not done, it is not punishable. To commit dacoity, it is also punishable. Preparation to commit depredation on the territory of a friendly power, it is punishable. Preparation to commit murder is not punishable unless the murder is committed. In which of the following section of IPC preparation is punishable? The section 121, 125, 398, or section 125, 122, 125 and 399, section 122, 126 or 399. In which of the following section of IPC preparation is punishable? Preparation is punishable under section 122, 126 and 399. One 122 is whoever collects men, arms or ammunition or otherwise prepares to wage war, it is punishable. And 126 talks about whoever commits depredation or prepares depredation, it is also punishable. And 399 is talking about making preparation to commit dacoity. All these are punishable. Preparation is punishable under section 122, 126 and 399. Section 124A of IPC prescribes punishment for sedition, waging war against the government, abetting mutiny, aiding escape of a prisoner. It is sedition. Which section of the Indian Penal Code defines sedition? Section 122, no. Section 123, no. Section 124, it is also no. Section 124A. Section 124 defines about sedition and it prescribes the punishment for sedition. Under which of the following sections of the Indian Penal Code? 1860, a conspiracy to wage war against the government of India is punishable. It is under section 121A. To wage war against the government of India is punishable under section 121A of the Indian Penal Code. 120 is criminal conspiracy. Whoever wages war against the government of India or attempts to wage war shall be punished with imprisonment up to 14 years with fine, death or imprisonment of life with fine, imprisonment up to 10 years with fine, or imprisonment up to 7 years with fine. No. Whoever wages war against the government of India, the punishment shall be death or imprisonment of life with fine under section 121 of IPC. Waging or attempting to wage war or abetting waging of war against the government of India is punishable under section 121 of the IPC. It is section 121 of IPC. A sent through the post offices a packet containing seditious publications with a covering letter requesting the addressee to circulate it to others. It was intercepted and never reached the addressee. A committed the offense of sedition, did not commit any offense, is guilty of inciting communal riot, is guilty of an attempt to commit sedition. He is guilty of an attempt to commit sedition. Which sections of the Indian Penal Code provide for the offence relating to the Army, Navy, and the Air Force? Section 171A to 171I, Section 123 to 129, Section 131 to 140, Section 165 to 171. The offences relating to Army, Navy, and the Air Force is provided in the sections 131 to 140 of the Indian Penal Code. Which of the following is neither an offence against person nor against property? Cheating, sedition, robbery, or murder? It is sedition. Sedition is an offence against the government established by law under section 124A of IPC. Therefore, sedition is neither an offence against a person nor against property. It is an offence against the government. Which one of the following is an essential ingredient of sedition? Dishonest intention, malafide intention, words spoken must cause public disorder by acts of violence, words spoken must be capable of existing disaffection towards the government. Essential ingredient of sedition is the words spoken must be capable of existing disaffection towards the government. Which of the following is not an essential element of unlawful assembly? 5 or more persons are required for unlawful assembly. Common object, to resist the execution of any law or of any legal process. Common intention, it is common intention is not required. It is not an essential element of unlawful assembly. Option D is correct. 5 or more persons is required, a common object is required, and to resist the execution of any law or of any legal process. The term unlawful assembly means an assembly of 5 or more persons, an assembly of 5 or more persons armed with lethal weapons, an assembly of 5 or more persons with a common object of doing a crime, an assembly of minimum 2 persons having common intention to commit a crime. The term unlawful assembly means an assembly of 5 or more persons with a common object of doing a crime. For application of section 149 of IPC, the offender must be a member of unlawful assembly. The offence must have been committed in prosecution of the common object. Both A and B, either A or B. It is both A and B. The offender must be a member of the unlawful assembly. The offence must have been committed in prosecution of a common object. Both A and B are correct. Section 149 of the Indian Penal Code 1860 is a declaratory provision, creates a distinct offence, a rule of evidence, all of the above. Section 149 of the IPC is a distinct offence. It creates a distinct offence of unlawful assembly. B is the answer. Rioting while armed with deadly weapons is punishable under IPC in section 159, 146, 147 and 148. Rioting while armed with deadly weapons is punishable under section 148. The punishment is imprisonment that may extend to 3 years or with fine or both. Punishment for rioting under the IPC is for 2 years only, for 3 years, for 2 years or fine or both, for 3 years or fine or both. Rioting while armed with deadly weapons, the punishment can extend up to 3 years or with fine. But this is a normal rioting. Punishment for rioting under the IPC It is not talking about that deadly weapon. So the punishment here in this case will be for 2 years or fine or both. In Indian Penal Code, punishment for writing is provided under section 145, 146, 147 or 148. It is under section 147. Use of violence by a member of an assembly of 5 or more persons in furtherance of common object will constitute affray, assault, rioting, unlawful assembly under section. It will be unlawful use of violence. Violence is there by member of an assembly of 5 or more in furtherance of common object will constitute. If there were no violence, the offense would have been unlawful assembly. As violence is involved, then the offense will be rioting. It is under section 146. Use of violence by a member of an assembly of 5 or more persons in furtherance of common object will constitute rioting under section 146 of IPC. To constitute the crime of affray, what is necessary among the following? Fighting at least 5 persons, fighting in public place, fighting in a market, use of weapons. To constitute affray, the fighting should take place in a public place. That is under section 159 of the IPC. When 2 or more persons by fighting in public place disturbs the public peace, then that is known as affray under section 159 of IPC. When 2 or more persons fight in a public place and commit breach of peace, they commit affray. Imputations, assertions prejudicial to national integration have been provided under which of the following sections of the Indian Penal Code? Section 154, 153A, 153B, or none of the above? It is section 153P. Imputations, assertions prejudicial to national integration have been provided under section 153B. Rioting means use of force or violence by an unlawful assembly or by a member thereof in prosecution of common object of such assembly as per section 144, section 145, section 146 or section 148. It should be section 146. Rioting is defined in section 146 of Indian Penal Code. For an assembly to be unlawful must have a common object of the kind specified in section 140, section 142, section 141 or section 144. It is in section 144. For an assembly to be unlawful, that is unlawful assembly, which is defined under section 149, it must have a common object of kind specified in section 144 of the IPC. Maximum sentence of imprisonment that can be awarded for the offense of affray is 3 months, 2 months, 1 month or 6 months. For an assembly to be unlawful must have a common object of the kind specified in section 144, section 140, 141, 142 or section 144. For an assembly to be unlawful, the common object specified in section 141, not 144, it is section 141. the common object are given or specified in section 141 of the IPC. Maximum sentence of imprisonment that can be awarded for the offense of affray is 3 months, 2 months, 1 month or 6 months. For an affray, the maximum punishment given can be 1 month. Minimum number of persons required for affray under section 159 of the IPC is 2. For an affray, the minimum number of persons required is 2. A private doctor running his own clinic refuses to provide medical treatment to B, a victim of acid attack. A is liable under which of the following sections of the Indian Penal Code? Section 166, Section 166B, Section 166A, or Section 167. Section 166 is talking about public servant disobeying law. Punishment for non-treatment of victim, it is provided under section 166B. So 166B is the correct answer. Which one of the following offenses cannot be committed at a private place? Cannot be committed at a private place. It is affray. For affray, it is to be the public place. It cannot be committed in private place. Which of the following does not constitute an offense of affray? 5 or more persons by fighting in a public place disturb the public peace. Which of the following does not constitute an offense of affray? It is 5 or more persons by fighting. Affray, fighting is required. In a public place is required. Disturbing the public peace is required. This is not required. 2 or more person is required. Section 153AA has been inserted in the IPC 1860 by which of the following Criminal Law Amendment Act? Act of 2001, Act of 2003, Act of 2005, Act of 2006. The punishment for section 53 is providing punishment for knowingly carrying arms in any procession or organizing Section 153 is providing the punishment for knowingly carrying arms in any procession or any gathering. So section 153A, the following Criminal Law Amendment Act 153AA has been inserted. It is inserted by Act of 2005. By this Act of 2005, this section has been inserted, which provides provision for punishment for knowingly carrying arms in any possession. Under which one of the following sections of the Indian Penal Code 1860 promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc. and doing acts prejudicial to maintenance of harmony has been dealt with? Section 153, Section 153A, Section 153AA, Section 153B. It should be Section 153A. Section 153A. Under these sections, promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony has been dealt with under section 153A. And section 153 is talking about only giving provocation with intent to cause riot. And 153B is imputations asserting this, all this. 153A is the right answer. Promoting enmity between different groups on grounds of religion is punished under which section of the IPC? It is section 153. Obviously 153A. Section 153A. Promoting enmity between groups on grounds of religion is punished under which section of the IPC? It is 153A. Which one of the following sections of the Indian Penal Code 1860 uses the word want only? It is section 153. Want only is used in section 153. Want only giving provocation with intent to cause riot. It is a deliberate and unprovoked way. It is want only. Want only is a deliberate and unprovoked way of causing a riot. Under section 153, want only word is used. Under Indian Penal Code 1860, the offence of affray has been defined in section 146, 148, 159 or 149. The word affray is defined in section 159 of the IPC. Which one of the following sections of the Indian Penal Code is an extension of the principle of respondent superior to criminal law? Section 121, section 159, section 120A, section 154. Section 121 is talking about waging war. Section 159 is all about affray. Section 120A, it is criminal conspiracy. And section 154, it is which is unlawful assembly is held. It is extension of the principle of respondent superior to criminal law is given under section 154, that is owner or occupier of a land on which unlawful assembly is held. Respondent superior to criminal law, it is an occupier of a land or owner of a land on which unlawful assembly has been held. This is given under section 154, that is in the extension of the principle of respondent superior to criminal law. Which one of the following sections of the Indian Penal Code deals with vicarious liability? It is section 154. This is vicarious liability. So in this example, say he is the owner of a land. A is the owner of a land. He has not done anything, but some people gathered here and organized unlawful assembly. So A is also guilty. This is known as vicarious liability. The land being A being the owner of the land is liable for the offenses committed by this unlawful assembly. This is known as vicarious liability. Indian Penal Code deals with vicarious liability. This section 154 deals with vicarious liability. Section 120A, it is criminal conspiracy, and section 159 is affray, and section 154, it is talking about vicarious liability. Personating a public servant is an offense under section 186, under section 171, under section 170, or under section 169. It is under section 170. It is personating a public servant is an offense under section 170. Section 186 provides for obstructing a public servant in discharging of public functions. And section 171 is wearing garb or carrying token covered by soldiers, and it is under section 169 public servant unlawfully buying some property. It is given in section 169. So the personating a public servant is an offense which is provided under section 170 of the Indian Penal Code. Unlawful assembly has been defined in the Indian Penal Code. The sections 141, 146, 149 or section 151. It is under section 141. Which offense does not require of minimum number of 5 persons? In writing, 5 persons is required. Dacoity, 5 persons is required. In affray, 5 persons is not required. 2 person is required. Which section of Indian Penal Code defines personation at elections? Personation at elections, it is defined in section 171D. Personation in election, it is defined in 171D. 171A, it is definition of candidate and electoral right. 171B is talking about bribery, and 171C is undue influence at elections. It is definition of a candidate, it is bribery, and it is undue influence in elections. So the personation at elections is defined under section 171D. Bribery is defined in section 171B. False statement is in connection with an election is mentioned under which section of the Indian Penal Code? 1860. Under section 171G, under section 171H, under section 171D, or under section 171E. It is under section false statement in connection with an election is mentioned under section 171G of the Indian Penal Code. It is 171G of the Indian Penal Code. Section 171E is talking about punishment for bribery, and 71H is about illegal payments in connection with election. Illegal payments in connection with elections. This is personation at election. So 71G is false statement in connection with an election. A being legally bound to produce a document before a district court intentionally omits to produce the same. A has committed the offense under which section of the IPC? Section 177, section 173, section 174, or section 175? It is section 175. Section 177 is talking about furnishing false information. 174 is about non-attendance in obedience of an order from public servant, and section 173 is about preventing service of summons or other proceedings. It is preventing service of summons or other proceedings. Section 177 is providing false information. and 74 is about non-attendance in obligation to order from any public authority. So A has committed the offense under section 175 of the IPC if he has intentionally omitted to produce some document which he is supposed to produce before a district court. Section 175. A refused to answer a question which is relevant to the subject concerning which the public servant is authorized to inquire. A is liable to be punished under section 179, under section 180, under section 181, or under section 173. A is liable to be punished under section 179 of the IPC. Section 181 is about false statement, and section 180 is refusing to sign a statement, and 73 is prevention of service of summons. Service of summons, that is prevention of service of summons, that is 173. False statement 181. 180 is refraining to or refusing to sign a statement. Under section 179, A refuses to answer a question, and under section 80 he refuses to sign a statement. A landholder, knowing of a murder committed within the limits of a state, willfully misinforms the magistrate of the district that the death has occurred by accident in consequence of the bite of a snake. A is guilty of the offense under section 177, 178, 179, or 182. It is under section 177. 177, that is furnishing false information. A is furnishing false information. So A is guilty of the offense of false information under section 177 of the IPC. 179 is refusing to answer. 178 is refusing to take oath. 178, and 182 is giving false information. 177 is the correct answer, giving false evidence. Giving false information. It is under section 177. Under Indian Penal Code, fabricating false evidence has been defined in section 191, section 193, section 192, or section 197. It is section 192. Fabricating false evidence has been defined in section 192. Section 193 talks about punishment for false evidence. Section 191 is talking about punishment for false evidence, and it is defining false evidence. Section 192 is fabricating false evidence, and section 197 is issuing or signing false certificate. It is issuing or signing false certificate. Corrupt usage of fabricated evidence as true with the knowledge that the evidence is fabricated is specifically punishable under section 193 of the Indian Penal Code, 196 of the Indian Penal Code, 199 of the Indian Penal Code, or section 198 of the Indian Penal Code. It is punishable under section 196 of the Indian Penal Code. Corrupt usage of fabricated evidence. 193, it is punishment for false evidence, and corrupt usage of fabricated evidence as true. It is punishable under section 196 of the Indian Penal Code. As per section 195A of IPC, which is inserted by the Criminal Law Amendment Act 2005, The offense of threatening any person to give false evidence is punishable with imprisonment up to 7 years or with fine or both, imprisonment up to 5 years or with fine or with both, imprisonment up to 3 years or with fine or both. It is imprisonment up to 7 years or fine or both. Punishment for giving false evidence in court is provided under Section 198, Section 193, Section 196, Section 197. It is section under giving false evidence. It is provided under Section 193. The punishment is imprisonment up to 3 years. A puts jewels into a box belonging to B with the intention that they may be found in that box, and these circumstances may cause B to be convicted of theft. A has committed the offense under which section of IPC given below? Section 191, Section 193 or Section 192. It is under Section 192, fabricating of false evidence. Fabricating of false evidence. It is under Section 192. Section 191 is giving false evidence, and Section 193 is punishment for false evidence, and fabricating false evidence is given in Section 192 of IPC. Whoever being legally bound by oath to state the truth or being bound by law to make a declaration upon any subject matter is said to give false evidence when he makes a statement which is false, he makes a statement which he believes to be false, he makes a statement which he does not believe to be true, all of the above. He makes a statement which is false, he makes a statement which he believes to be false, that means the statement is false. He makes a statement which he does not believe to be true, that is false. So all of the above. Whoever being legally bound by oath or by an express provision of law to state the truth or being bound by law to make a declaration upon any subject makes any statement which is false and which he either knows or believes to be false or does not believe to be true is said to have committed contempt of court, an offense giving false evidence, an offense of fabricating false evidence, and none of the above. It is an offense of giving false evidence under Section 191 of IPC. Section 195A of IPC is related to protection of witness, protection of victim, threat to give false evidence, none of the above. It is threat to give false evidence. Which section was incorporated into IPC by the Criminal Law Amendment Act 2005? It is Section 195A. How much punishment may be given to a person accused of giving false evidence in a judicial proceedings? 7 years of imprisonment, 7 years of imprisonment and fine, 7 years of imprisonment or fine, 5 years of imprisonment and fine. It is 7 years of imprisonment and fine. Which of the following is not correctly matched under IPC? Furnishing false information is provided under Section 177. Giving false evidence, it is not correctly matched. It is correctly matched. Causing disappearance of evidence of offense in Section 205, and counterfeiting coin is under Section 231. It is causing disappearance of evidence of offense. It is provided in section 205. It is wrong. 205 provides false personation for purpose of act or proceedings in suit or prosecution. It is not correct. Which one of the following offences under the Indian Penal Code is exclusively triable by Court of Session? Section 185, Section 195, Section 205 or Section 215. It is Section 195, giving or fabricating false evidence with intent to procure conviction of offense punishable under imprisonment for life or imprisonment. Which among the following offense, this offense under section 195 is exclusively triable by a court of session? What is given under this section is that giving a fabricating false evidence with intent to procure conviction of offense punishable with imprisonment for life or imprisonment. That is section 195. A. Make a false entry in his shop book for the purpose of using it as corroborative evidence in a court. He committed the offense punishable under section 191, section 192, section 193 or section 194. It is section 193, giving punishment for giving false evidence. This is under section 193. Disclosure of identity of victim of rape is punishable under section 326A, 228A, 228 or 376E. The victim of rape is punishable under section 228A of the Indian Penal Code. 326, it is talking about acid attack, victim of acid attack. It is 228 is intentional insult or interruption to public servant, and 376E is punishment for repeating offenders, and 228A is the disclosure of identity of certain victim of certain offenses. That is the disclosure of identity of the victim of rape is punishable under section 228A of the Indian Penal Code. A. Knowing that B, C, D, E, F and G are about to commit the offense of dacoity in Kathmandu, Nepal, harbors them in his house in Sitamarhi, Bihar, with the intention of facilitating the commission of such dacoity. A has not committed any offense, as the dacoity was yet to take place, not committed an offense that can be tried in India, committed the offense of harboring dacoits, committed an offense which can be tried and punished only in Nepal. A has committed the offense of harboring dacoits. When a person tries to escape from lawful custody while taken to a magistrate to furnish security for good behavior, would be punished under the provision of section 224, 225, 225A or 225B. It is under section 225B. 225 is persistence or obstruction to lawful apprehension of other person. Person tries to escape from lawful custody, it is punishable under section 225B. Which section of the IPC provides punishment for dishonestly making false claim in court? section 179, section 205, 209 or 211. It is 209. Punishment for dishonestly making false claim in the code, section 209. Offense of destruction of electronic record to prevent its production as evidence is punishable under IPC in section 201, 202, 203 or 204. It is under section 204. Destruction of electronic record to prevent its production as evidence is punishable under IPC in section 204. A, knowing that B has murdered Z, hide the body with the intention of screening B from punishment. A is liable under section 302, 109, 204 or 201. It is under section 201. Using a true, any such declaration known to be false is dealt under section 199, section 200, section 201 or section 202. It is under section 200. Using a true, any such declaration known to be false is dealt under section 200. A, knowing that B has murdered C, assist B to hide the body with intention of screening B from punishment. A is liable for punishment to 7 years with 7 years of imprisonment and fine under section 201 of the IPC. International omission to give information of offense by a person legally bound to inform is dealt under section 202 of Indian Penal Code, 203, 204 or 205. It is not international, it should be intentional. Intentional omission to give information of offense by a person legally bound to inform is dealt under section 202 of the Indian Penal Code. A imports into India or exports therefrom any counterfeit coin knowing the same to be counterfeit. He is guilty under section, which section of the IPC? It is section 237 that provides possession of instrument or material for the purpose of using the same for counterfeiting coin. It is section 237.